All right, hello everyone. It's noon and I am mindful of your lunch hour, so I'm going to go ahead and get started because we have a lot to cover. Welcome to another edition of the Holland and Hart Health Law Basics webinars. Like all of our webinars, this is going to be recorded, both for you to re-listen to it later if you need it, but also to torture me with the sound of my own voice when I listen to it back. But you can find our health law webinars on the Holland and Hart Health Law website if you need to access the materials later. And then also you should have received a copy of the PowerPoint presentation and then just some materials that I've found helpful. Important information, because we are lawyers, this presentation is for educational purposes only. Not legal advice. It's not intended to create an attorney-client relationship. And as always, if you have specific questions of the application of law to your activities, please seek the advice of your legal counsel. Here are my preliminaries. This is just an overview of the relevant laws, and there are a ton of them. So I will hopefully be able to get through everything within the next hour. We're going to go through a lot of stuff, and we don't have a lot of time. So if you need specific information on anything in particular that I talk about, just go ahead and reach out to me after this webinar is over, and I will get back to you. And then always remember to keep in mind your specific state laws. We don't have, I'm in Idaho, but we don't just have Idaho folks on the line. So I may not know necessarily what Utah or Wyoming has to say about a specific topic, but we can find someone who can find the answer if you need that. What we're going to cover. I set this up, and I hope it works. I set it up so first we go through the background of all the federal laws and regulations that affect the industry, and then an overview of state regulation generally, just because I don't want to get into the specifics of a bunch of different state laws. I will probably refer to Idaho law a few times just because I know Idaho law. Then I'm going to talk about pharmacy law basics, and when I get into the pharmacy law basics, I'm going to go back and reference the federal laws that we discussed in the beginning. And then we're going to go more into the federal laws and regulations governing controlled substances, DEA and state registration and licensure requirements, and then we'll talk about state prescription monitoring programs and also drug disposal issues. So here are the agencies involved in drug and pharmacy regulation, and in my exhaustion last night, I've left out Department of Health and Human Services. So that should also be in there. FDA, obviously, DEA, those are the biggies. Center for Medicare and Medicaid Services, the Ftca, the CPSC, Joint Commission, and then state boards of pharmacy. Those are, in each state, the Board of Pharmacy is really going to have a lot to say. So who's affected by all of this regulation? Well, pretty much everybody who touches drugs from start to finish. So let's just dive right into federal drug regulation. Here's a quick overview. As you can see, that's a long list, and it's not even exhaustive. I'm not even touching fraud and abuse laws or anti-discrimination laws or the ADA. All of those also affect pharmacies. But the ones that are bold, and hopefully you can kind of see that they're bold on the screen, are the ones I'm going to talk about in a little bit of detail, some of them in not so much detail, but I think it's important to get sort of the background of how everything came about in order to have a full understanding of what's going on today. So the Pure Food and Drug Act of 1906 prohibited interstate commerce in misbranded and adulterated food, drinks, and drugs, and the penalties under that act were seizure of the questionable products or prosecution of the responsible parties. And this is really where the modern regulatory functions of the FDA began, but there were gaps. It did not regulate cosmetics or medical devices, and it also didn't require ingredients to be listed. So the FDA, as it existed, didn't really have enough power in its opinion. And how I'm going to go through these laws is chronologically. The Robinson-Patman Act of 1936 was an anti-price discrimination law. And under the Robinson-Patman Act, it prohibits institutions that buy drugs at favorable discounted rates from selling the drugs at cost to others. However, the Nonprofit Institutions Act, which was later, exempted from this prohibition the purchase of supplies for their own use by nonprofit hospitals. Under the NPIA, eligible nonprofit entities may purchase and vendors may sell to them supplies at reduced prices for the nonprofit's own use. And own use has been interpreted to mean for use by the entity in the sense that such use is part of and promotes the entity's intended institutional operation. The specific requirements for own use by hospitals is outlined in case law in Abbott Laboratories case, and then also in Ftca advisory opinions. And that guidance is really helpful and very specific. If you need it, just let me know and I can send it to you. The Food, Drug, and Cosmetics Act of 1938. This is the big one. It is still the law. But it's been amended many, many times since its enactment. It replaced the Food and Drug Act of 1906 after the FDA petitioned Congress and said, hey, we need more teeth here. And there was a pretty heated battle in Congress, but eventually it passed and it was signed by FDR. Among other things, what it does is requires drug manufacturers to provide scientific proof that new products could be used safely before putting them on the market. It added cosmetics and devices. It added that poisonous substances in food is prohibited except where it's unavoidable or required in production. And it gave the FDA specific authority for factory inspections. I'm not going to talk so much about FDA regulation, but the most recent Holland and Hart webinar that was done on May 14th by one of my colleagues is on the FDA regulation of medical devices. So if you're interested in more information there, you can go on our website and check it out. Notable amendments that affect pharmacy under the Fca. The Durham-Humphrey Amendment in 1951 established the two classes of drugs, the RX Legend and the over-the-counter drugs. Prior to passage, drug manufacturers were generally free to determine in which category their drug belonged. Guidance as to what minimal information must be included on a prescription label was included in that amendment, and then the amendment allowed prescription refills. Then in 1962, the Drug Efficacy Amendment required drug manufacturers to show the effectiveness of their products as well as their safety, report adverse events to the FDA, and ensure that advertisements to physicians disclose the risk of products. And importantly, it also established informed consent for human research subjects. This amendment arose out of thalidomide being prescribed. It was viewed as a super drug, but it was prescribed for lots of different things, but one of the things that it was prescribed for was morning sickness in pregnant women, and it caused a lot of birth defects. And so the Drug Efficacy Amendment arose out of that and implemented the good manufacturing practices that you see today and gave the FDA authority to regulate advertising and marketing of prescription-only and over-the-counter drugs. It also gave authority to regulate advertising and marketing of dietary supplements, but they gave that authority to the FTC. The Controlled Substances Act, which I'm going to talk about a lot later, so I won't belabor it here. It provides for the classification, acquisition, and distribution of controlled substances, registration and verification of prescribers, and appropriate record-keeping requirements of controlled substances. Poison Prevention Act of 1970. I'll talk about this a little bit later, but it gave the Consumer Product Safety Commission authority to require special packaging of household products and drugs to protect children from serious injury or illness. And manufacturers are required to perform tests to ensure that children under 5 would find the packaging significantly difficult to open. Although some might say that they've maybe taken this too far because adults often find the packaging significantly difficult to open. But all legend drugs and controlled substances must be packaged in a child-resistant container, though there are exceptions, which we'll talk about. Failure to comply with the packaging requirements is considered a misbranding violation under the FDCA. The Drug Price Competition and Patent Term Restoration Act, more commonly known as the Hatch-Waxman Act, provides standards for marketing generic drugs without the necessity of the new drug application process. Instead, they can go through the abbreviated new drug application process to get FDA approval of the generic. They've got to be therapeutically equivalent to the pioneer drugs, and then the FDA published the Orange Book, which is, according to the FDA, a guideline, but some states actually do require following it. So check your state rules. Prescription Drug Marketing Act of 1987, or the PDMA. They increased safeguards in the drug distribution system to prevent the introduction and retail sale of substandard, ineffective, or counterfeit drugs. And I'll talk a little bit more about counterfeit drugs later because there's some new or newer legislation and regulations that are in effect or going into effect fairly shortly on that. But it was enacted to ensure that drug products purchased by consumers are safe and effective and avoid the risk of counterfeit, adulterated, misbranded, subpotent, or expired drugs, and required the labeling of drugs as samples. It also required wholesalers to be licensed under state law according to federal standards. And it banned the sale, trade, or purchase of drug samples and drug coupons. OBRA 87, the Omnibus Budget Reconciliation Act of 87, also this portion of it was known as the Federal Nursing Home Reform Act, and it was enacted to protect the rights of residents in long-term care facilities, and it gives CMS the authority to enact measures to reduce costs and improve quality. It really emphasizes quality of life and quality of care for its residents and allows residents to self-administer medications if an interdisciplinary team has determined that the practice is safe. Additionally, requirements under OBRA 87, the resident's drug therapy must be free from unnecessary medications and from those given in excessive doses, in excessive duration, or without adequate monitoring. And nursing facilities must ensure that medication error rate does not exceed 5%. So a little bit more on this. Nursing facilities must provide routine and emergency drugs and biologicals to its residents. The provision of pharmaceutical services includes assurances of accuracy in acquiring, receiving, dispensing, and administering of medications and biologicals for each resident. Nursing facilities must employ or obtain the services of a licensed pharmacist who provides service consultation, establishes the record-keeping system to track receipt and disposition of all controlled substances, and determines that medication records are in order. And at least once per month, a licensed pharmacist must perform a drug regimen review for each resident and report any irregularities to the attending physician or director of nursing. So that's all under OBRA 87. And then OBRA 90, this really affects pharmacies. It addressed the pharmacy practice standards, included requirements for pharmacists relating how to interact with patients. There were the drug utilization review requirements in OBRA 90, the offer to counsel, record-keeping requirements, and I will talk about this in more detail. Hipaa. I am not going to spend this presentation talking about Hipaa and pharmacies, but as you know, Hipaa affects all covered entities and business associates of those covered entities. Prescribers and dispensers are covered entities. Pharmacies have been hit up for violations. You may have heard of a specific pharmacy that may have been involved in dumping protected health information in the dumpster behind the pharmacy. So I'm just going to go ahead and say, don't throw PHI in the dumpster, and that's your tip of the day. But if you need more information about Hipaa, we have a ton of resources on the Holland and Hart website, and you can listen to the previous Holland and Hart webinars on it for everything that you could possibly need to know. 340B drug pricing program. I could spend an entire webinar just talking about 340B because it's so complex. Instead, I'm going to talk about it in one slide. And if you have questions about it or need more information, please don't hesitate to ask. My contact information will be at the end of this presentation. So Section 340B of the Public Health Services Act, that's why it's called the 340B Drug Pricing Program. It was enacted in 1992, and it is administered by the Health Resource and Services Administration. The pricing program requires drug manufacturers to provide covered outpatient drugs to eligible healthcare organizations, which are known as covered entities, but they're different from Hipaa covered entities, and provide these covered outpatient drugs at significantly reduced prices. Covered entities are federally qualified health centers, rural referral centers, naval, tribal health centers, Ryan White programs, children's hospitals, CAUSE, disproportionate share hospitals, freestanding cancer hospitals, among others. There is a list of them. If you need the list, just let me know. To participate, covered entities have to register and enroll with the 340B program to get an identification number, and vendors have to verify prior to allowing the organization to purchase the 340B discounted drugs. HRSA guidance permits covered entities to contract with commercial pharmacies to dispense 340B drugs to eligible applicants. So those contracts with the contract pharmacies are incredibly important and have to include certain things. So if you need assistance with that, just let us know or consult your attorney. Food and Drug Modernization Act of 1997. This created a special exemption to ensure continued availability of compounded drug products prepared by pharmacists to provide patients with individualized therapies that are not available commercially. But it also seeks to prevent manufacturing under the guise of compounding by establishing parameters within which the practice is appropriate and lawful. And it also changed the terminology from prescription legend to RX only. Medicare Modernization Act of 2003 created the Medicare Part D prescription drug benefit. It's voluntary and it's not automatic. The Medicaid tamper-resistant prescription law of 2007 requires physicians and pharmacists to use either electronic prescriptions or tamper-resistant prescription pads for their Medicaid patients. Prescription pads must contain at least one tamper-resistant feature, but this only applies to outpatient drugs that are in written form. Verbal, fax, and electronic prescriptions are exempt. The Ryan-Haidt Act is something that we often get questions about. The Ryan-Haidt Act arose out of a young man who purchased a controlled substance online and died from it. And so Congress amended the Controlled Substance Act, and it does relate solely to controlled substances, so it does not have anything to do with non-controlled substances. And it's designed to prevent illegal diversion of controlled substances by means of the internet. So it places a number of restrictions on the practice of online pharmacies and the ability of practitioners to prescribe controlled substances over the internet. It regulates anyone who delivers, distributes, or dispenses medication by means of the internet, but it doesn't prohibit all internet pharmacies. Rather, what it does is it requires a valid prescription for a controlled substance to be based on at least one prior in-person examination by a physician. And there are a bunch of other restrictions, but this is the main one that we get questions about all the time. So a practitioner can be in violation of the valid prescription requirement if he or she does not perform at least one in-person assessment of the patient before prescribing a controlled substance. However, the Act exempts practitioners from the requirement as long as the practitioner meets the federal definition of practicing telemedicine. A physician practicing telemedicine may prescribe controlled substances without, I just realized there's a typo there, sorry, may prescribe controlled substances without an in-person examination if the patient is treated by and physically located in a hospital or clinic which has a valid DEA registration, and the telemedicine practitioner is treating the patient in the usual course of professional practice in accordance with state law and a valid DEA registration. So this is where you're going to want to check state law and make sure it is permissible. Idaho just passed the Telehealth Access Act, which will allow the initial evaluation to occur via two-way audiovisual interaction, so long as it still satisfies the community standard of care. The Affordable Care Act of 2010, you guys may have heard of it. The main goals of it were to increase access to affordable quality health insurance, reduce growth in U.S. healthcare spending, and to protect patients. Provisions that specifically affect pharmacy, whether they attempted to close the coverage gap, the donut hole in Medicare prescription coverage, and then accountable care organizations. It is something that pharmacists are going to be really important for. So the Affordable Care Act authorized CMS to contract with ACOs under the Medicare program. They are networks of physicians and other providers that work together to coordinate care and improve the quality of healthcare services and reduce costs for a defined patient population. The goal of the coordinated care is to ensure that patients get the right care at the right time while avoiding unnecessary duplication of services and preventing medical errors. And pharmacists are important to this model. Medication therapy management services focus on improving adherence to therapy and reducing hospital readmissions, which is incredibly important for coordinated care. The Secure and Responsible Drug Disposal Act of 2010 caused a lot of confusion. It was passed in an effort to curtail prescription drug abuse by authorizing regulations to outline methods for ultimate users and long-term care facilities to dispose of unused, unwanted, or expired controlled substance pharmaceuticals in a secure, safe, and responsible manner. I'll talk about this a little bit more later. But the Disposal Act authorized the DEA to promulgate regulations that allow ultimate users and then also long-term care facilities to transfer pharmaceutical controlled substances to authorized entities for disposal. The Drug Quality and Security Act of 2013 contains two separate acts. The Compounding Quality Act is one of them, allows compounding pharmacies to voluntarily register as outsourcing facilities. Once registered, they'll have to meet certain conditions in order to be exempt from the FDCA's approval requirement and the requirement to label products with adequate directions for use. And then the Drug Supply Chain Security Act, this is what I was referring to earlier with respect to drug counterfeiting. The Drug Supply Chain Security Act requires the FDA, not the DEA, so this is not just related to controlled substances, to create and implement a national track and trace system to deter drug counterfeiting. And the requirements are going to apply to the entire drug supply chain. Each entity in the supply chain, from the original manufacturer to the end distributor, is supposed to track the product coming in and out of its possession. And here are the deadlines. One just passed and one's coming up. January 1st, 2015, dispensers have to establish systems for verification and handling of suspect or illegitimate product. If you go to the FDA website, and I think I included some information in the materials, the FDA website has information about how to recognize a suspect product and how to see if it's illegitimate. July 1st, this is coming right up, dispensers must be able to provide lot-level product tracing information for 6 years. And that's going to be the transaction information, history, and statements. This information could be requested by the FDA or by state regulators. And this might prove more difficult for independent pharmacies that don't use electronic inventory management or ordering systems, but it should be pretty easy for the pharmacies that already have this electronic inventory management system. And importantly, the rules only apply to human prescription drugs, not yet to veterinary. All right, so those were the major laws that affect pharmacy, or the drug system in general. I'm going to get into now pharmacy basics and try to go through State regulation, qualification requirements, talk about telepharmacy a little bit, standards for prescriptions, and just the other requirements that I alluded to, like the patient counseling requirements, et cetera. So I'm going to, hopefully this will be helpful, but I am going to have to refer back to the federal laws that we discussed earlier. State regulation. So state boards of pharmacy regulate the practice of pharmacy. They generally have the authority to register pharmacies. There are different categories of pharmacy registration in some states. Pharmacist licensure, pharmacy tech licensure, registration, pharmacy intern registration. They have the authority to do inspections. They issue rules and regulations. They receive and investigate complaints, and then they also have the authority to discipline. This is very state specific. You're going to want to look at your Board of Pharmacy regulations in order to determine how pharmacies are regulated in your state. I just ran through the Idaho regulations, and they deal with pharmacy registration. There's a requirement that there's a declaration of a pharmacist in charge. There's space, equipment, and fixture standards that get really specific. Certain pharmacy references have to be on hand at all time, either hard copy or electronic editions. There's product storage requirements, security standards, business hour requirements, staffing requirements, supervision requirements, and change of ownership requirements. So if you have any of that stuff going on, you're going to want to check your Board of Pharmacy regulations in the state in which you are sitting. The practice of pharmacy definition also varies by state. I think they're pretty consistent, but some are more specific than others. As you can see, Idaho's is a little bit more specific than Wyoming's. In Idaho, the practice of pharmacy is the interpretation, evaluation, and dispensing of prescription drug orders, participating in drug and device selection, administration, doing the prospective and retrospective drug reviews, which we'll talk about, provision of patient counseling, and the provision of those acts and services necessary to provide pharmaceutical care. Boards of pharmacy, regulation of the pharmacist. The general, and I just kind of culled this from a few states, general licensure qualification requirements for pharmacists. They've reached the age of majority, have a good moral character, are a graduate from a school approved by the Board of Pharmacy, complete an internship or can demonstrate experience in the practice of pharmacy, successfully pass the exam, and pay the required fees. But again, look to your specific state requirements. Pharmacy tech requirements, minimum age, from what I've seen, it looks like just high school graduation or the equivalent is required. They've got to complete a training program and pass an exam, and they're only authorized to perform routine pharmacy support services under the supervision of a pharmacist. But we'll talk about pharmacy techs a little bit later when we talk about telepharmacy. More on techs. This is specific to Idaho, but I think it's pretty it's pretty common, this type of definition. So a pharmacist may assign and allow performance by a tech only those functions performed in pharmacy operations that meet certain criteria. The function has to be routine. The function has to be one that the tech is trained in. The function, it has to be performed under the pharmacist's supervision, and it cannot require the pharmacist's professional judgment. Technicians are prohibited from dispensing non-controlled substances, even if under the direct supervision of a pharmacist, but they may transact the sale and deliver the product after the pharmacist has fulfilled his professional and legal responsibilities. Other prohibited tasks or functions by a tech, I feel like it's kind of a no-brainer, but they can't consult with the prescriber prior to filling if clarification of information is needed. They can't perform prospective drug reviews or interpret clinical data. They can't perform professional consultations with the prescriber, nurse, or other healthcare professional. They can't supervise the packaging of drugs, and they can't provide patient consultations, and they can't supervise pharmacy operations. Also, in Idaho, techs must identify themselves as a technician on any phone calls initiated or received while on duty. So, telepharmacy. It's the delivery of pharmaceutical care via telecommunications to patients who may not be able to have direct contact with a pharmacist. So how it works is there's a licensed pharmacist at a central pharmacy site that is going to be supervising a registered pharmacy tech at a remote telepharmacy site through the use of two-way audio or video conferencing technology. You're going to want to look at state law again to just even make sure this is permissible. In the states I surveyed, Utah, Wyoming, and Idaho, the person preparing the drug for dispensing by the pharmacist must be a registered pharmacy tech. If controlled substances are dispensed at the remote site, the parent pharmacy must be registered with the DEA as well as the remote site. And then I was asked a question before this webinar started about telepharmacy and kiosks and the feasibility for kiosks. I am going to have to do a bit more research on that because I was not able to find anything quickly this morning when I was looking, and I'm sure that is also going to be controlled by state law. So if you have any questions about that, and for the person who asked me about it, I will look into it further and see if I can get an answer. Standard prescription labeling requirements. Generally, prescription drugs must be dispensed in appropriate containers that bears all of the following information. But again, check state law because there might be different requirements or there might be additional requirements. This is generally the requirement in every state, but there might be additional ones. And also there might be different requirements in your state for labeling for patient use while in a hospital. It may not need to be quite so much information. Drug product selection. Circling back to Hatch-Waxman when we were talking about generic substitution, the FDA classifies generic equivalent products that are approved as safe and effective, are pharmaceutical equivalents, are bioequivalent, are adequately labeled, and are manufactured in compliance with the good manufacturing practices. Products that meet this criteria are determined to be therapeutically equivalent, even though they differ in size or shape, release mechanisms, storage conditions, expiration, et cetera. When those differences are important in the care of a particular patient, it may be appropriate to require that a particular brand be dispensed as a medical necessity, and that's usually designated as fill as prescribed. The Orange Book, which I talked about a little bit earlier, is the FDA publication that lists many drug products and contains indications as to whether generic versions of medications are considered to be equivalent to the drugs manufactured by the innovator company. And like I said earlier, it's not an official legally binding regulation, but many states have adopted it. Going back to the PPPA and poison prevention requirements for pharmacists, failure to comply with the PPPA is an act of misbranding under the Fdca, so pharmacists can be prosecuted for violations. Pharmacists must dispense oral prescription drugs in special child-resistant packaging unless the drug is exempted or the patient or prescriber requests non-special packaging. An individual may issue a blanket request that all of his or her prescriptions be filled in a conventional non-special packaging. You're not required to get patient requests in writing, but it is highly suggested, and because we're lawyers, we're always suggesting that you get things in writing. So if someone just doesn't want to deal with this non-child or this child-safe, non-tamperable medication bottles, they can issue a blanket request saying that all of his or her prescriptions should be in the non-special packaging. Drugs dispensed to facilities where the staff administers the doses to residents does not need to be in special packaging. That would be a long-term care facility or a skilled nursing facility. It would not include assisted living facilities since they are allowed to administer their own medication. Potential penalties for violating this section of the FDCA, up to a year in jail or a $1,000 fine. So there are penalties for failure to comply. The patient counseling requirement, circling back to over 90, it requires the pharmacist, while exercising professional judgment, to discuss with the patient when the offer to counsel is accepted the following: the name of the drug, the intended use and expected action, the route, the dosage form, the administration schedule, common side effects or adverse effects, how this specific drug could interact with other drugs that the patient is taking, techniques for self-monitoring the drug therapy, proper storage of it, potential drug-drug interactions or drug disease contraindications, prescription refill information, and then action to be taken in case of a missed dose. But keep in mind that the pharmacist only has to discuss this with the patient when the offer to counsel is accepted. I just picked up a prescription yesterday, and on the little pin pad it's asked if I wanted counseling, and so I said no. So unless the offer to counsel is accepted, the pharmacist doesn't have to have this conversation with the patient. But also remember to check state laws, because at least in Idaho, there are regulations regarding patient counseling. Counseling a patient when the patient is not present. When prescriptions are delivered or mailed to patients, pharmacies are not exempt from the patient counseling requirement. Pharmacies must establish a process to offer patient counseling services when a patient is not present. So one method to ensure compliance is just to provide the printed drug information that includes the pharmacy business hours, as well as a toll-free telephone number so that the patients can call and speak with the pharmacist if they so choose. Mail order pharmacies commonly use this method. Some states have established regulations specifically for mail order pharmacies, so look to those. And it's common to require the pharmacy to provide information that includes a toll-free number on the prescription bottle or label, as well as the pharmacy's business hours. And then states may have specific regulations that require a mail order pharmacy at least to be open a certain number of hours and sometimes a certain number of days per week in order to be compliant. Okay, the Controlled Substances Act. Here we go. It is the federal policy under which the manufacture, importation, possession, use, and distribution of certain substances is regulated. It is a drug or chemical whose manufacture, possession, or use is regulated by the government. They are drugs or chemicals that have at least some potential for abuse or dependence. The Controlled Substances Act provides for the classification, acquisition, distribution of controlled substances, as well as registration and verification of prescribers, and it requires certain record-keeping requirements. There are 5 schedules of controlled substances. I won't read all of that, but Schedule 1 is your no medical use or treatment in the United States. These are the bad illegal drugs: heroin, ecstasy, etc. Schedule 2, these are the controlled substances that they have a high potential for abuse and but they do currently have an accepted medical use and treatment in the United States. So these drugs are highly regulated by the DEA, which we'll talk about. Schedules 3 through 5, well, 3 has a little bit less potential for abuse, and then Schedules 4 and 5 are controlled substances that have a low potential for abuse. Every person who manufactures, distributes, dispenses, imports, or exports a controlled substance must register with the DEA. A separate registration is required for each principal place of business or professional practice at one general physical location where controlled substances are manufactured, distributed, imported, exported, or dispensed by a person. These are the registrant types listed on the DEA's Office of Diversion Control website. And I have to say, the DEA's website is really good. So if you need any guidance on this, the DEA has so much information on their website. But this list of the registrant types, that's it. That's the list of what you can register as in order to in order to deal with controlled substances. Note on there that long-term care facilities are not listed. So long-term care facilities are not registrants. So each pharmacy that dispenses a controlled substance has to be registered with the DEA. That's the DEA Form 224. The certificate of registration has to be maintained at the registered location and kept available for official inspection. And if you own and operate more than one pharmacy, each place of business must be registered. To renew, the DEA Form 224 is available online. Chain pharmacies can use DEA Form 224B in lieu of a separate registration application for each pharmacy registration. You cannot renew online more than 60 days prior to the current expiration date. And if the expiration date passes and no renewal has been received by the DEA, the pharmacy no longer has any authority to handle controlled substances. So watch those deadlines. Practitioners have to register and obtain a DEA registration number. States may also require a controlled substance registration. In Idaho, that is the case. But note that issuance of a DEA number does not permit all practitioners to write all prescriptions for all ailments. For a prescription to be valid, the practitioner must prescribe for a legitimate medical purpose and be acting in the usual course of sound professional practice. The DEA has authority to deny, suspend, or revoke a DEA registration upon finding that the registrant falsified their application, has been convicted of a felony related to a controlled substance, had a state license or registration suspended, revoked, or denied in another state, has committed an act which would render the DEA registration inconsistent with the public interest, or has been excluded from participation in the federal health care program. To order controlled substances, Schedule 3 through 5 drugs can be purchased by a pharmacy or other appropriate dispensary on a general order form from a wholesaler. Schedule 2 drugs have much more stringent requirements and must be ordered with DEA Form 222. DEA Form 222 is required for each distribution, purchase, or transfer of a Schedule 2 controlled substance. Once a registrant has received a DEA registration number, they can go online and order additional DEA Form 222s, and they come in a book, and each book has 7 sets of forms, and each pharmacy is provided a maximum of 6 books at one time unless its needs exceed the limit. There is also an electronic form, which I'll talk about in just a minute. For receiving controlled substances, for Schedules 3 through 5, carefully check in the drugs against the purchase order, including the product name, quantity, strength, and package size. For Schedule 2 substances, you really need to check it against the Form 222. And then the executed Form 222 needs to be maintained separately from the pharmacy's other business records. Lost or stolen order forms. These forms are very important. If a pharmacist has not received an expected shipment of controlled substances, he or she should first contact the supplier to determine whether the original form was even received. If it was lost or stolen, then the pharmacist needs to complete a second order form so that the supplier can fill the original order. And then the pharmacist has to prepare a statement to attach to that, which includes the first order form serial number and date, and verify that the drugs ordered were never actually received. And then, upon discovery of the loss or theft of used or unused order forms, the pharmacist has to immediately report the loss to the local DEA diversion field office and provide the serial numbers of each lost or stolen order form. There is the opportunity to use electronic order forms via the DEA Controlled Substance Ordering System. There are a fair amount of requirements, though, in order to do so. So here are the prescription requirements under the Controlled Substances Act, and pharmacists need to know the requirements for a valid prescription for a controlled substance. So dated and signed on the date when issue, patient's full name and address, practitioner's full name and address, practitioner's DEA registration number, the drug name, the drug strength, the dosage form, the quantity prescribed, directions for use, number of refills authorized, if any, and then written in ink or indelible pencil or typewritten and must be manually signed. Although you can do it electronically. Prescriptions for controlled substances may only be issued by a physician, dentist, podiatrist, mid-level practitioner, or other registered practitioner who is authorized to prescribe controlled substances by the state in which they're licensed to practice, registered with the DEA or exempted from registration, or if the practitioner is an agent or employee of a hospital or other institution acting in the normal course of business under the registration of the hospital, provided that certain additional requirements are met. When the prescriber is responsible for, while the prescriber is responsible for the proper prescribing and dispensing of controlled substances, a pharmacist has a corresponding responsibility. The pharmacist is required to exercise sound professional judgment when making a determination about the legitimacy of a controlled substance prescription. Such a determination is made before the prescription is dispensed. A pharmacist who deliberately ignores a questionable prescription when there is reason to believe it was not issued for a legitimate medical purpose may be prosecuted along with the issuing practitioner for knowingly and intentionally distributing controlled substances. So going back to the valid prescriptions, March 31st, 2010, interim final rule on electronic prescriptions for controlled substances. Practitioners can write prescriptions for controlled substances electronically, and pharmacies can receive them so long as certain conditions are met. So pharmacy must use a pharmacy application that meets all the regulatory requirements, and then the prescription must otherwise conform with the other requirements of the Controlled Substances Act. Emergency dispensing of controlled substances is permitted. A practitioner can telephone a Schedule II prescription to the pharmacist who may then dispense the prescription, but there are requirements. Basically, it has to be reduced to writing, and it's got to be limited to the amount needed to treat the patient during the emergency period. Partial filling of Schedule II prescriptions is allowed for terminally ill or long-term care facility patients. They can be filled in partial quantities to include individual dosage units. The pharmacist just needs to record on the prescription whether the patient is terminally ill or a long-term care facility patient, and it needs to be marked terminally ill or a long-term care facility patient. Otherwise, it will be deemed to have been filled in violation of the Controlled Substances Act. For refilling Schedule II controlled substances, can't do it. But an individual practitioner may issue multiple prescriptions authorizing a patient to receive up to a total of a 90-day supply of a Schedule II controlled substance, provided certain conditions are met. And then for Schedules III and IV controlled substances, they may be refilled if authorized on the prescription, but they can only be refilled up to 5 times within 6 months after the date of issue. After the 5 refills or 6 months, whichever occurs first, a new prescription is required. Schedule II prescriptions cannot be transferred to another pharmacy. Schedules III through V prescriptions may be transferred only from the pharmacy from which it was originally filled and never from the pharmacy that received the transfer, except that pharmacies that electronically share a real-time online database can transfer up to the maximum refills permitted by law and the prescriber's authorization, but also check state law requirements on this. The record requirements are, if you go to the DEA's website, they have a lot of information about record-keeping requirements. But essentially, controlled substance registrants have to keep accurate records and maintain detailed inventories. They've got to keep records of each substance disposed of or sold or received by the registrant, and then all records related to controlled substances must be maintained and available for inspection for a minimum of 2 years. But also check state law on this, because some states have different record retention requirements. I believe Idaho's is 3 years. For violations of the Controlled Substances Act, they can be civil or criminal in nature, which can result in administrative, civil, or criminal proceedings. Penalties can range from modification or revocation of your DEA registration to civil monetary penalties to jail or prison time, depending on the nature and scope of the violation. Prescription monitoring programs, they are somewhat related to the Controlled Substances Act. They involve controlled substances. Almost all states have prescription monitoring programs in place The purpose of, I mean, they use them differently, but almost all of them have them in place. The purpose is to identify potential diversion and abuse of controlled substances by the patient, pharmacy, or prescriber. Pharmacies report controlled substances prescriptions to a designated state authority electronically on a periodic basis. The information reported to most prescription monitoring programs: patient name and information, prescriber name and information, pharmacy identification, and prescription information. Last time I checked, only Delaware required pharmacists to actually check the prescription monitoring data prior to dispensing. That's important because I think if a lot of states start requiring pharmacists to check the prescription monitoring data prior to dispensing, I think that could subject pharmacists to a fair amount of liability. So last I checked, it was only Delaware, but it's been a while since I've checked it. I haven't updated that research yet. Drug utilization reviews, referring back to OBRA 90 again, condition of participation in the Medicaid program, and it's, you need to look to state law. Generally, for retrospective drug utilization reviews, there's a DUR board that's made up of physicians and pharmacists that are going to review medication use trends and data. For a prospective drug utilization review, active resolution of drug therapy problems through a comprehensive review of a patient's prescription order at the point of dispensing. So that's going to be the pharmacist's obligation. In Idaho, at least, Idaho requires the pharmacist prior to dispensing any prescription to complete a prospective drug utilization review, which has to include all of these considerations. All right, drug disposal. Disposal of controlled substances by registrants is regulated by the DEA. Disposal of non-controlled substances, you're going to look to state law and the EPA. And then disposal of controlled substances by end users in long-term care facilities who are not DEA registrants is also regulated by the DEA. So the whole goal of the Controlled Substances Act is to provide this closed distribution system so that the DEA knows where the controlled substance is at all times until it reaches the ultimate user or it's destroyed. So there are rules governing the disposal of controlled substances. It can occur in several ways. The dispenser can return the controlled substance to the manufacturer so long as the manufacturer accepts the returns. The dispenser can dispose itself of the controlled substances so long as it follows certain procedures, basically by submitting DEA Form 41. The method of destruction must render the controlled substance to a state of non-retrievable and meet all applicable destruction requirements, and 2 authorized employees must declare in writing that they personally witnessed the destruction. A dispenser can also distribute the controlled substances to a reverse distributor, and the reverse distributor is an entity that is going to dispose of the drugs for the dispenser. For Schedule II controlled substances, the reverse distributor is going to have to issue a Form 222 to the dispenser. So again, with that whole closed system, cradle to grave, the DEA wanting to know where the drugs are at all times, the Form 222 needs to be issued to the dispenser by the reverse distributor. And then keep in mind, reverse distributors can only be used by DEA registrants. So they're not an option for long-term care facilities because long-term care facilities are not registered with the DEA. For Schedules 3, 4, and 5, if you're using a reverse distributor, the reverse distributor is responsible for submitting the DEA Form 41 when the controlled substances have been destroyed. Disposal of non-controlled substances. Most pharmaceutical waste is classified as non-hazardous or solidus waste, but some of it can be hazardous. And in that case, we have to look to the Resource Conservation and Recovery Act, because why not? Let's just throw in some more laws. Hazardous waste. Generators of certain amounts of hazardous waste are regulated by both the EPA and the individual states. Most states have adopted the EPA regulations. Some have more stringent requirements. The EPA is currently in the process of developing a new proposal to establish appropriate standards for the management and disposal of hazardous waste pharmaceuticals generated by healthcare facilities. They have a whole website on it, but we have nothing. We've been waiting since 2008. So until those new rules are finalized, healthcare facilities need to manage hazardous waste in accordance with RCRA Subtitle C. And so that's when you have to look at the monthly output of hazardous waste and determine under which category you fall, if you are a conditionally exempt small quantity generator, a small quantity generator, or a large quantity generator. Some states have different definitions. There are two types of hazardous waste, listed waste and characteristic waste, and there are 29 chemicals considered listed waste that are also used as, or that are used as pharmaceuticals. And this list is from the EPA website. So if there's any mistakes, it's the EPA's fault. Characteristic wastes are regulated. So these are listed wastes here. Characteristic wastes are regulated because they exhibit certain hazardous properties. RCRA defines 4 characteristics of hazardous waste: ignitability, corrosivity, toxicity, and reactivity. So if you're not a listed waste, you need to determine whether a drug formulation exhibits one of those 4 characteristics. All right. This I'm going to talk about quickly because it looks like we are almost out of time. Disposal of drugs by ultimate users in long-term care facilities. So the Secure Responsible Drug Disposal Act of 2010 I talked about earlier did cause a fair amount of confusion, but it was passed to curtail prescription drug abuse by allowing ultimate users and long-term care facilities to dispose of unused or unwanted or expired controlled substances. So they're not just sitting around in people's medication cabinets or sitting in storage closets, et cetera. Keep in mind it only applies to controlled substances. The Disposal Act authorized the DEA to promulgate regulations to allow ultimate users to transfer the pharmaceutical controlled substances to authorized entities for disposal. So the goal is by these regulations that came out in September to encourage both public and private entities to develop a variety of collection methods and collection and disposal in a secure, convenient, responsible manner. It authorizes ultimate users to transfer unwanted and unused pharmaceutical controlled substances to an authorized collector. And I'll talk about those in a second. Long-term care facilities and persons lawfully entitled to dispose of a decedent's property may also transfer the controlled substances to an authorized collector. So a long-term care facility for the purpose of these regulations is defined to mean a nursing home, retirement home, mental care, or other facility or institution which provides extended health care to resident patients. It may dispose of pharmaceutical controlled substances on behalf of the ultimate users. Since they're not actually registrants with the DEA, a long-term care facility is acting on behalf of the ultimate users. But interestingly, what these regulations did was they are allowing them to dispose on behalf of ultimate users through a collection receptacle that is maintained by an authorized collector. And for long-term care facilities, an authorized collector can be a hospital clinic with a retail or with a pharmacy or a retail pharmacy on site, and so they can offer these collection receptacles. But note that the rule does not provide a framework for disposal of controlled substance pharmaceuticals that have accumulated in long-term care facilities if there's no on-site receptacle. So authorized collectors may collect pharmaceutical controlled substances from ultimate users using one of the following methods, either collection receptacles or mail-back programs. Authorized collectors must be registrants already, and that is why a long-term care facility cannot be an authorized collector because they're not registered. The following categories of registrants may modify their registration to become collectors if they're authorized to handle Schedule II controlled substances. Hospital clinics with on-site pharmacies and retail pharmacies are on that list. And what you can do is you can just go onto the DEA diversion website if you decide you want to be an authorized collector and just modify your registration, and there's no fee to modify the registration for that purpose. Retail pharmacies and retail pharmacies and hospital clinics with an on-site pharmacy are the only ones that can manage the collection receptacles at long-term care facilities. Becoming a collector is voluntary. No person is required to establish or operate a disposal program. The DEA suggests that there are advantages that might accrue directly to these entities that opt to maintain a disposal program, mostly that they're going to increase their consumer presence and they will increase their goodwill. That is what the DEA suggested. So I don't know how many people or how many entities are going to want to become authorized collectors, because authorized collectors are liable for the receptacles. So I imagine the agreements between the authorized collectors and the long-term care facilities are going to include indemnification provisions, although I haven't seen any and I don't know what it's going to look like. Let's see, since we are out of time, I am just going to move right on to resources. Here are some good websites, and we also provided you with some resources as well, I believe, in an email that went out earlier today. Here are our upcoming Health Law Basics webinars. The next one is July 9th, and that's going to be on telemedicine. And hopefully I will have information about pharmacy kiosks by that time. So thank you guys so much for listening, and please, if you have any questions, you can go ahead and email me. If I didn't cover something that you wanted to be covered, just go ahead and email me and I can find you some additional information. But there's my email address, or you can call me directly. So thanks so much.